welcome you all to this Zoom meeting. We are NMBF Coffee Chats. So we are basically a Christian forum, discussion forum, but we also have programs that are for the society. And today is one such social initiative that we have taken for the society to know about nomination and power of attorney. And I want to also acknowledge and thank Rosie Norona, who has been instrumental in organizing this meeting. So what we'll be doing is we have our resource people, Advocate Sharon Rodrigues and Advocate Chandravali Nair. So they'll be speaking in this first half for a length of time. And after that, we will have the Q&A. So I request you all to keep your mics on mute. And if you have any questions, please put it on the chat. It will be addressed in the second half. Okay. So just a quick introduction of our speakers this evening. Now we have with us Advocate Sharon and Advocate Chandravali. Advocate Sharon started her practice since 2014, and Advocate Chandravali started her practice from 2015. So both of them work together as a team, and they handle civil and criminal litigations in major Mumbai courts, including High Court, Family Court, and Magistrate courts. Besides, they also provide legal consultancy and all documentation services, including compliance for cooperative housing society on retainership. Advocate Sharon has completed her master's in social work in 2004, and she has been practicing as a lawyer since as early as 2011 under her late father, Advocate Leo Cardos. Yeah. So we want to welcome both our speakers. Thank you so much for being here today evening and sharing your knowledge, your expertise in this field. So over to you, to both our speakers. Yeah. Thank you.
So thank you very much for this introduction and giving us this opportunity, sir and Rosie. As we begin the session, this document, what we will be speaking today, as Abhijit sir said, that is on power of attorney and nomination. I will begin with the slide. You can put the slideshow.
Yeah, sure.
Can go to the next slide. Okay. Power of attorney is a very, very common document. We hear a lot of times, we have to make a power of attorney. But understanding the highlights of this power of attorney is very, very important because it is easily made. I see many people. In fact, today itself, there was a client who came to me and he has given a power of attorney. But when I asked him what is in the power of attorney, he says, I don't know. When I asked him, you don't know? He says, no, I know that I made a power of attorney, but what are the factors in the power of attorney? What are the clauses he has entered is so crucial in determining the power he has given to another person, okay? Failing to realize that once you make a power of attorney, a registered power of attorney, what happens and the consequences of it. So I'm glad that you all have organized because this topic was never ever taken. We have taken so many topics, but this topic seems very crucial. Okay, because as individuals, as lay people, okay, as social workers or any professional in the field, when we give any power of attorney, we need to understand each and every statement we put in that paper. So we are accountable, and even the person who we are giving the power, okay, should be accountable for the trust. A power of attorney is normally given to a trusted person. So when we make a power of attorney, we should be clear as to what is the power we are giving another person. So with the presentation, I will begin with 2-3 slides, then Advocate Chandravali will take over and she will add in between. Okay, we need to firstly understand that the power of attorney is a legal document. Okay, the instrument, okay, it is an instrument where one person, okay, the one person is giving power to the other person to act on his behalf. So the person who is giving the power, okay, there are two parties here. The person who is giving the power is called the principal, okay, and the person receiving the power is called the agent. So these terminologies understanding is very, very crucial. And second thing is a person who makes a power of attorney must be 18 years and above. Now, what happens in certain cases if the person is a minor? Okay, the power of attorney is given to an adult to deal with any aspects with regards to the minor. Okay, but the person has to be 18 and above. Both the parties who's making the power of attorney should be of sound mind. Now, what happened? There are certain cases, okay, there are certain cases where we see that there are some people who have lucid moments, okay, so that at one point of time, that person may not be in a mental frame of mind to make it. But when he is making the power of attorney, if it is proven that during the time of making he was of a proper mental frame of mind, that power of attorney is considered valid. But if it is proven that that person was not of the sound state of mind during the making of the power of attorney, then that power of attorney will be considered not valid and not a legal document. Okay. To confer authority or power on another person to act on his or her behalf, as I already mentioned. So you are giving all the rights on specified aspects. Okay, so for instance, you have a property in a particular place. You are giving your rights for a person to deal with every aspect of a particular property. Okay, now what happens is sometimes what happens is we give, there are different concepts of power of attorney. One is a general and one is specific. So when I'm giving someone a power of attorney, okay, when I give general, means I'm giving the powers to the agent to deal with every aspect of my properties or dealing with court matters, everything I'm giving a general power of attorney, which I mentioned in the power of attorney. Whereas in a specific power of attorney, what happens is you are giving only with a specific aspect. Now, why this is very crucial, when we mention that the title of the power of attorney, we write general power of attorney, specific power of attorney is very, very crucial to mention, because that gives a legal binding, okay, to deal only with that aspect of the property or with the principles details. Okay. Receiver of power is a lawful attorney. Okay. So who is receiving the power? Okay. Who's receiving the power should be a lawful attorney. The attorney should be ready and willing to accept the power. When we say over here, the attorney should be ready and willing to accept the power. When we make the document, we write over there, okay, that it is accepted. That word accepted is over there when we sign. If you all have seen a power of attorney, we write over there for the attorney that the attorney power of attorney has been accepted by the person. Now, what happens is this power of attorney, okay, is valid as long as during the lifetime of both the parties. So both should be in living when this power of attorney is existing. If either one of the party passes away, unfortunately, sudden death, then the power of attorney cease to exist. Okay. Next slide. Okay. POA is a legally enforceable document. Now, when we say POA is a legally enforceable document, means this document, okay, so for instance, if we are preparing a testamentary petition, if the client is staying abroad and his sister is here handling, so he gives the power to his sister to handle the High Court testamentary petition. So it is, but this when we produce in the court of law, this kind of power of attorney has to be registered with the sub registrar. Okay, in front of a government official, it has to be registered. So it's enforceable. But when we are producing this power of attorney in the court of law, it has to fulfill all the conditions of the power of attorney. Okay, there should be two parties. Then they see every aspect of it in the power of attorney. There should be two signs, signatures or witnesses when the power of attorney is made front of the register. So if all these aspects are covered in the power of attorney, then only this power of attorney is accepted in the court of law. Okay. As we have put, it is admissible evidence in the court of law. Operates during the lifetime of either or both the parties. Power of attorney is convenience to an aged parent. So normally what we do is now presently Advocate Chandra ma'am is also, we are presently working on a testamentary petition. So someone who is sick or aged cannot come to the High Court or whatever, then we request the person to give the power of attorney. And normally, if you see, you must be knowing power of attorney is normally made, you choose the attorney from your family. Okay, from your family. But even I would strongly recommend, if it even it is your family member, please read every clause of what you have written in the power of attorney. What powers you are giving that person is very, very crucial to understand. Okay, because when you go in the court of law, some if any ambiguity is there, okay, there are various factors in the court of law. If their power of attorney has ambiguity, how the court interprets this power of attorney, okay, I will add to that later. Granted to a trusted member of the family. POA is generally executed by individuals to handle property matters, court litigations. A lawful attorney acts as a trusted agent accountable to his principal. So, the idea of the power of attorney is that the person who you have given the powers is a trusted individual. So, you believe that the person will do everything in the interest of the principal who has given you the powers. Okay. PO is ease of handling and managing properties scattered geographically. So when you say that, if you are given the powers, if someone is not in the state of, he's in Kuwait or he's in Bahrain. So if I have got the power, I can deal, and he has given me the rights. So I can deal with any property of his, any part of India, but it has to be a registered power of attorney. Okay. PO is a handy tool when a non-resident of a country has to manage his asset in another country. A company can expand business through their authorized agent by executing a POA. Okay, this company means he has given a person, okay, or one of the trustees or one of the members, managers, CEO, to extend the business of the company. So POA is given. A power of attorney is irrevocable, meaning guarantor power can withdraw the power in the event of a suspected fraud on the part of an attorney. So suppose if I have made a power of attorney and I have a suspicion that this power of attorney is being misused, okay, it is important that you revoke. Now, how you revoke also is very, very crucial. When you revoke it, and it is a registered power of attorney, you may give a verbal revocation can be done or a written revocation. But now what happens in this case? So suppose I have made a power, Advocate Chandra ma'am, and I have given a power of attorney and I want to withdraw it. I need to also inform the sub registrar where the power of attorney was registered, telling them that I have revoked it. Or if I have given to all the parties in that property where I have put clause that this person can deal with this property. So suppose if it's a society, I tell the society that I had given this power of attorney to so and so person, but now I have revoked it. So there should be no further transactions with based on this power of attorney. Okay. Next, next slide. Okay. So there are two types of power of attorney. One is general and one is specific. General is you give every power, all with every aspect, you give the powers to make a leave and license, to fight in court, to represent here, to represent at the BMC. Anyway, you give a general power of attorney. Whereas specific, you mention this person will, specific means, I mean, he will represent or she will represent me in the High Court in the testamentary petition. Second, he will only be appearing for me in the matter. He will not receive any kind of payment or check in this. So you have to be very specific what he will do. Okay, so when it comes to monetary and all, you have to be very clear that this person will be restricted only to this aspects of the powers and no money transaction to happen with the attorney. Okay. Since POA is a legal document, it is advisable to get it drafted by a professional only to avoid ambiguity. Now, very often, Advocate Chandra ma'am also will agree with me that there are documents which we go online and we just collate it and we write the power of attorney, we write the will. But what happens is when we present, when a lawyer does it, okay, we see the aspects of ambiguity in the sense of how the court will interpret it if this statement and if it is made in a wrong manner, how can it be interpreted if it is not very precise, how the court can interpret it, okay, in interest of the principle, of course, but being drafted by a professional is very crucial. Okay. General power of attorney is a blanket permission granted by the guarantor to perform a series of tasks on his behalf. Hence, expert advice in favor of a. So normally, what we are trying to say here is avoid making, not avoid, but preferably make specific power of attorney. Refrain from giving general power of attorney. Okay. In other words, authority or attorney ceases once assignment is complete. So what happens in a specific power of attorney? You have given that task to that person to continue with my property in Vasai. So that person deals only with the Vasai property. So the minute that transaction is over, the redevelopment is over, the minute the entire process is over, then the power of the person, attorney, ceases to exist. Okay. So it's very, very important that we be more specific. Advocate Chandra, would you like to take over from here?
Yeah, I will like to go to the previous slide
Yeah,
because
please.
I'll take your discussions a little forward by giving
Okay.
some illustrations so
Hmm.
layperson would understand, what
Yeah.
we are trying to tell
Hmm.
them. So can we go to the previous slide and the previous slide also?
Hmm.
Okay. So when I say it is a valid contract, means two people are involved in it, grantor and grantee. So when the two people are involved, here we say that they should be majors, 18 complete, they should have completed 18 years of age, and they should be physically and mentally fit. That means a father who is having an Alzheimer's cannot give a power of attorney to his children or whoever, because when an aged person goes to the court for registering a document, necessarily they will ask for a medical certificate, medical fitness certificate. The doctor has to necessarily certify. So this is very, very important. If the person is not medically fit, no document executed by him will be registered by the registrar. So he cannot give any power of attorney. Pardon? Is that clear? Advocate Sharon, I think I
Yes,
made
yes.
Yep.
this illustration. Okay, so this is what I mean by two parties. The giver knows that he giver or receiver. Both have to be medically fit. So if the registration, for registration, this is a mandatory condition. We have to have a medical fitness certificate. Then, yes, that is, it takes forward my sound state of mind. Then all the definition part, Advocate Sharon has explained. So lawful attorney. Now, when we say it is a valid contract, and if at all, power of attorney registration is compulsory in India, and a registered power of attorney alone is admissible as evidence in the court of law. Why we say that is, now we go to the next slide. Pardon? And now it's a legally enforceable document. Why I say is, if the attorney plays any kind of fraud, he can be dragged to the court, so that you can file a suit against him. That is, the grantor or the principal can file a suit against the attorney. So he will be sued for his acts, because this document is a legally enforceable document and admissible. Next point comes from that only. Then operates during the lifetime of either or both parties. One of the parties is dead, the power of attorney stops there. So then again, this aged parents and all, we aged, that we covered that. Now, in case of a business house, what happens? The boss, your manager or a director, he gives a power of attorney to one of his trusted employees to act on his behalf. So once, if at all the employee resigns, then again the power of attorney becomes invalid. Then somebody has to take over, it has to be a fresh document. So that employee will not have any right to act on the power of attorney. So that is one thing. It means if I give illustrations, it will be more clear. Sharon, I think
Yeah.
I've made it clear, no?
Yes,
Now,
yes.
yes, when individuals are handling property matters, and especially bosses also give, companies also give power of attorney to the to handle the court litigations, because the boss doesn't want to come to the court very often, so he gives his to its employees. So that is one thing. Now, if we talk of a public trust, public trust. Now so many businesses in our country, we see how the business entity expands. Now you have in companies like Indian Oil Corporation, HPCL. Now they are all having so many petrol pumps. Now you will be seeing so many petrol pumps. We see Indian Oil petrol pump, we see HP petrol pump, but these are not actually HP or Indian Oil or Bharat Petroleum. These are all power of attorney holders for the company. I think I made this is an illustration which makes it very clear. So, but these are power of attorney holders for HPCL or BPCL. So, BPCL or HPCL is the principal, and these petrol pumps are attorneys. That is how they run these petrol pumps. And in case of a public trust also, what is a trust? Trust is also a trust, and a trustee is an attorney, lawful. In a way, he is a lawful attorney of the government. The trust properties in a way belong to the government. All the trust properties, immovable assets, all belong to the government. So you are holding for the government. That is what it is. Now, then I think now we talked about non-resident Indians. Non-resident Indian who is presently employed somewhere, but he is in India, he has some property. So any trusted person, he can assign the task, he can give a power of attorney so that he can manage his properties in India. Or people who are residents of India, they can manage their business outside India. That also through a power of attorney, specific power of attorney. So these are some of the illustrations. Revocable. Now this revocable, here I would like to say something is in a power of attorney, we have various clauses. So we can add a revocation clause. So that becomes a binding clause on the attorney. Because once you say that if any suspicion, you will revoke the power of attorney, means that itself is a binding clause. And once you say that it is revocable on 1 month's notice on either side, something like that. Some clause you have to add, so that makes it all the more clear. So there is no clash. You go here, there, nothing. He goes to the court, I go to the court, nothing like that. That's all. I give a 1 month's notice and your power will be revoked. Now we go to the next slide. Now here also general and specific. As Advocate Sharon said, that general power of attorney is something many people give to everybody. So that is a risk factor because it gives a wide, it's a sort of a blanket permission to do anything you want. So we generally recommend specific power of attorney, which is very limited, means it doesn't operate life, it does operate for lifetime. But if you are giving a developer, development rights to the developer are given on a specific power of attorney. Once the project is over, his power is withdrawn. It automatically comes to an end. So that is an example of rights granted to a developer. I think that is clear. Right, no, Sharon?
Yes, yes, ma'am.
Yeah, this is okay. So, see, when we give illustrations, lay people understand fast, no?
Mm.
So this is a specific power of attorney. Normally, all the development projects here, when we take any real estate projects which are going on, the landowner is somebody else who gives a power of attorney to a developer. Development rights are given on the land, but then he doesn't take away his, that doesn't take away his rights on the land, landowner's rights on the land, unless he surrenders, conveys the land to the developer or the tenants, whoever come later on. So that is why we see that most of the development projects, the building comes up, flat owners buy the flats, and developer is still there in the premises. He's going on, he has his own office, he's going on collecting the maintenance, so many things. This is an awareness part, that because the landowners' rights are still reserved. It is the property is not conveyed to them. So that is one, because these are the areas where we get confused. like we got the flat, but there is no society is formed for 4 years, 5 years, things like that. So this is one area that assign power to. So I think that covers, right?
Yes.
I think we have clarified, and within the given time, we have clarified the topic as such. है ना?
Yeah,
So
I
we
would
go to
like
the next.
to add to this. See,
Hmm.
one thing is power of attorney is not transferable. So suppose if you
Hmm.
say the attorney has passed away, okay, so the
Hmm.
legal representative don't become a part of the power of attorney, it just ceases to exist.
Hmm.
Secondly
Correct.
is uh, uh, now what happens? A PO is made, okay, to not to communicate between the principal and the agent, but more to communicate to a third party that there is the power given to a attorney to create to follow his to do his business. Okay, so it's more
Hmm.
in interest to inform the third parties that this agent can enter into any agreement or do any dealings with regards to the principal. Now, another thing is when it reflects ambiguity, okay, when it reflects ambiguity, a power of attorney, okay, for instance, if a power of attorney grants authority to buy, sell, and manage property and to do all other things necessary to protect my interest, okay, it's written over there. So now,
Hmm.
if there is any ambiguity with regards to the POA, what the court will consider is now if to protect my interest, to do all other things necessary to protect my interest. Now this will become little ambiguous. So all my interest. So court will say that are you trying to say the person will say that he said all the interest, so I can handle all his property. But in this case, what happened? The court clearly said that buy, sell, and manage my property. So here it was only, court said it is in reference to this property. You cannot say because the statement in the ending said to do all other things necessary to protect my interest. So the court clearly said it is reference to this property only. Okay. If the
Bona
donee,
fide interest
yeah, bona fide
safeguard.
interest.
Hmm.
And so
Yes.
another thing is, okay, if anything in the donee, so you have given a power of attorney only for certain thing, and if he does anything beyond it, that is not binding on the on the principal. So if
That
he
is his
has,
responsibility.
yeah, that is his responsibility. Even if he has violated something or done anything unlawful, misusing the power of attorney, so the principal will not be charged for it, but the attorney will be charged for it. Okay, and most importantly, yeah. Okay. Now, very important is suppose if the power of attorney, the person who gave the power, the principal passes away. Okay. Now, what in one of the cases which I was reading a case law, okay, but if there is in this power of attorney a valuable consideration, okay, a valuable consideration in this power of attorney, then it will continue to exist though the principal has died. I'll give you an example. A landowner grants an irrevocable power of attorney to a developer to sell the land and construct a property with the developer receiving a share of proceeds or a commission. Okay, so he has given a power of attorney, the landowner, to develop the property. Okay, on certain consideration that if you develop, you will get so and so benefits. If the landowner dies during the development process, the POA can still be valid to allow the developer to complete the project and secure their interest according to the lands of Maharashtra. So am I clear? So even after the death, it is prevailing
Specific. Hmm.
because there is a consideration clause over here.
Hmm.
Okay?
Hmm.
Yeah?
So that has to be made clear in the power of attorney itself.
Yes,
So
yes,
the
yes.
clauses have to be included accordingly.
Yeah. Okay. And also, as ma'am already said, that when you're revoking it, very, very important that the revocation also has to be done in the register office where you made the power of attorney. And I'm sure ma'am also will agree that you cannot do power of attorney with notarization. Avoid notarization. It's very, very crucial that you register a power of attorney. Okay? Yeah. Abhijit, so you can go to the next slide. Okay.
Hmm.
Yeah. Specific power of attorney is considered to be saved. I think this we have. Okay, yeah.
Yeah, we completed this.
Okay, enforceable document
Registration is
registration of the same is
compulsory.
compulsory in
Huh,
India.
now,
Yeah.
now one more thing I would like to add is power of attorney holder is not the owner of the property of his principal. He has no ownership rights on the property. That he must. So that is where the fraud part comes. Sometimes, like they exceed their powers, and this is one thing. So you can very well give a power of attorney, lawful power of attorney, specific to anybody, and register it, so that he doesn't become an owner. That is one very important, because people are scared how to give the power of attorney, because then they may grab the property. That is one fear they have. So in other words, no attorney right, ownership rights on the attorney. Registration involves minimal stamp duty and document handling charges. The minimal stamp duty 500,000, whatever it, depending upon the department costs. So it's not a big, very expensive, like, but the legal fees you will have to bear. Then both parties have to appear before the sub registrar along with two witnesses at the time of executing the document. It is just like registering any property. So I think with that we complete, no,
Yes,
Sharon?
yes.
Yeah,
Yeah,
our
you can go to
audience
the
may
next
have
slide.
some questions. We will take later
Later,
or
yeah.
now. Okay, go on to the next slide now. We have almost all covered all the points, I think. Now this is nomination. Sharon, would you like to start?
I know you can take over, Advocate Chandra.
Now, nomination. Nomination again is a very simple thing we always hear. Nomination is the act of entitling someone you trust with your own assets. I am talking of nomination in case of legal terms of nomination. The bank, when you open an account in the bank always asks you to file a nomination form, and this nomination form is very well. Now, the person who nominates is the nominator, and the person who is nominated is the nominee. That is clear. Now, nomination in most cases takes effect after death of the nominator. This is what it is. Now, nomination, what happens during the lifetime of the nominator, the nominee has no role to play. He is neither the owner of the asset, nothing is. And he cannot act on behalf of the uh, nominator during the nominator's lifetime. That we have to be very clear. That means if the bank account is being operated by a certain person, A has a bank account, and then he has filed a nomination form also. Now, this is a very confidential document which the bank has with it. So, no nominee can appear for the account holder. He has himself to go, he has to sign all those things. So this is what we say, that nomination in most cases takes effect after the death of the nominator. Now, legal heirs usually approach the banks or companies to inherit assets of the nominator. Now, the assets may be in the form of bank accounts. These are the movable assets we are talking about. And in case of companies, it is share certificate, debentures, whatever. So here also, in the case of share certificate, the nominee may be aware that he is being nominated. But in case of bank account, he may not be aware. He will come to know only after the death of the nominator. When he goes, the legal heirs go to the bank, and then this is an FD which my father was having, this is the FD my mother was having, she had this, that, and all. Then the bank will say so and so is the nominee. So nominee can appear before the bank. They can prove their credentials and take hold of the assets. This is what happens in case of movable assets. Now, in case of companies, they may have some slightly different formalities, if at all. They will tell you what is to be done. So, accordingly, you can comply, do the compliance, and get hold of the assets of the nominated. Now, nominee has to prove his credentials, and this I have covered. If there is more than one nominee. Now, here is this is a very critical thing. Now, in case of let us say that A has an FD in a bank, and he has nominated X, his son or somebody. So if the X can take hold of the account, but if there are more than one nominees, then like the others may have to give their consent also at times. Usually, in case of cash and bank fixed deposits, this doesn't happen. They will give it to the nominee only. But if the other legal heirs take an objection, then bank has to give a second thought. That is where the banks also sometimes ask for succession certificates and legal heirship documents, because when there is a clash between the other legal heirs and the nominee, then these kind of things happen. So next is, in some cases if there is more than one nominee, the institution may insist on this slide. The bottom part is not visible. uh, Sharon ma'am, can you just raise it a bit, the slide,
I
this
think
the
to
last
us
point.
you can read it. I think Advocate
Yeah,
Sharon, because it's visible to us.
in some case, I think there is.
In some cases, if there is more than one nominee, the institution may insist on a succession certificate to endorse legal heirship and consensus
Hmm.
between nominees.
I
And
covered that.
yeah.
So we go to the next slide now.
Okay, before going to the next slide, also I
Ah,
wanted to share
ah,
in case, okay,
hmm,
in case
hmm,
you will have a bank locker. Okay.
hmm,
Now the
hmm,
bank locker, if even if you have a nomination, they will not give you what is in the locker. You will have to get a LOA, or you will have to get a certificate from the court saying that you are the next nominee to the bank locker. Because, and
hmm,
also what I would suggest is, with my experience, normally if suppose if you have a joint with a bank locker with anybody, now, what happens is if you know, okay, or if you know that the person suddenly expired, one of the parties suddenly expired, I would suggest don't inform the bank. First, you remove the thing and then later on inform the
then
bank.
you,
Never
yes.
inform the bank immediately when a person expires.
Hmm,
Okay,
hmm,
wait for some time and
hmm,
wait for, because sometimes there is a money entry coming into the bank. So hold on, okay, and then
hmm,
inform the bank after a period of 2 weeks or 3 weeks that okay, this has
hmm.
happened, this unfortunate thing has happened. But immediately informing the bank, my suggestion through my experience, through some cases, don't inform the bank immediately.
This is the same case with demat accounts and
Yes,
even
yes.
the normal bank deposits,
Hmm.
where there may be checks, debenture checks, this and that, all these may be coming in. So you just wait for some time, 6 months or even a year, before you inform the bank about the death of the uh, account holder.
Hmm.
Now,
Yeah.
nomination in most case takes it that we
Next
have done.
slide.
Legalize, yes. Next slide.
Yeah.
We go to the next slide.
Hmm.
Hmm. Nomination is the will of the nominator. Usually, it is the will of the nominator. But here also, there are some exceptions. What happens? Usually, the nominator has a bank account, but then he found that his son is not taking care of him. His legal heirs are not taking care of him. There is a third person who is taking care of him. So he wants to give his money to that person. So he usually makes this nomination. That is why we say nomination is in most cases is confidential or not known to the nominee. Why it is not known to the nominee is because the nominator can always change the nomination if any untoward incidents happen, because people behave very weirdly, even the family members also weird, because of their weird behavior. The nominator can change his decision and change the nomination with whatever assets he wants to give to someone, in order to avoid misuse of the provision of nomination. Confidentiality is in order to misuse the provision. That's what. Because if the nominee knows well in advance that my father has left so much money for me, he may as well kill their. Nowadays, these things we hear, no? They kill they give some medicines to their parents and withdraw money, things. All these things they do. So that, in order to avoid that, the banks usually keep the nomination as a confidential. Then now the nominee can be a third person other than a close relative. Usually it is a close relative, but it can be a third person also. Some people would want to say that I was staying in an old age home, so I want to give all my money to the old age home who took care of me. So to the any kind of trust, charity, whatever it is. So it need not be necessarily the family member who is always a nominee. Now, In the next point is again same. Nominee can be more than one and can be changed during the lifetime of the nominator. So you can delete nominees. If there are three nominees, you can delete two, you can add one. Now this happens now in case of supposing if you have a provident fund account, then you have to approach the EPFO. The nominator would have already given his form to the PF office saying that I have three children and a wife, so each one of them should get 25% of my EPF money. Or he would say that my wife should get 50% and the rest of the 50% should be divided equally amongst my children. Something like that. So this facility, it is very flexible nomination facility. So that takes care or secures the legal heirs. And it is also safe to the nominee. Now, nomination in case of movable assets is mandatory. Nomination to avoid future disputes and confusion among the legal heirs. So if somebody has a four FDs, then you can just give one to one person, the second one to second person, like that. So that facility is there. Now nominees cannot disburse, alienate movable assets of the nominator during the latter's lifetime. So if the nominator, as long as he is alive, his assets will remain his only. Only after his death, the nominee will come into picture as per his rights. Now, nomination does not create ownership of the nominator's property. Shall we go to the next slide
Yeah,
now?
yeah. Hmm.
Now, nomination for immovable property. Now, this is where most of the people have a misunderstanding. Many people, flat owners, they say that no, we have already nominated somebody to our on the that name appears on the share certificate. So that nomination for immovable property has a very limited applicability. I mean to say that the flat owner's nominee can only pay the maintenance, he can pay the electricity bills, and he can take care of the flat. He can stay there for some time, that's all. But not more than that. Be it anybody, be it be anybody, means this nominee may be his children, his wife, whoever it is. But he or she doesn't become the owner of the flat, even if he has been nominee on the society records. Now, bank
And
locker
also,
here
I'd
we
like to
say,
add that
yes,
as ma'am has already said, okay, so suppose if you have, 50%, your husband and wife. So with one spouse passing away, not because one spouse is living, it doesn't mean that the entire 50%, though he is
100%.
nominated. Okay, you
Yes,
don't become
yes.
100% ownership. You don't
Owner.
get ownership. That other
No.
50%, you still have to get a set test. You have to still get a LOA from the High Court saying that 50% be transferred to my name. Okay, so it
Hmm.
is not that because one spouse died, you automatically become the ownership rights.
Owner of the
Yeah,
property. So
because you're the
nomination
wife
doesn't help.
or yeah. Even if you're
So
the only
now,
surviving heir of that person, that person, you still have to go to High Court to get the order in your favor. Hmm? Yes,
hmm.
Advocate Chandra, yeah.
Now, a bank locker is an immovable asset. Now, it is a now in case of a bank locker, usually the bank takes an agreement. It makes an agreement at the time of taking a locker. So there, the nomination is given. So if the nominee is there, if the other legal heirs are okay with it, then this nominee gets access to the locker. Otherwise, the bank locker is treated as an immovable asset. The bank wouldn't allow you to touch it also. You go and get a letter of administration, succession certificate, whatever, and then only we will allow you to touch the bank locker. That is how it is. And because here you can't play fraud on the bank also, because since there is no nomination, he is a singly holding the locker. You go and sign, the bank will come to know. So they will insist on a LA, and then you'll have to go for it. So however, so bank locker is an immovable asset, we say. Here again, the next thing I have covered. Nominee will become the owner of the locker only subject to proving his credentials and NOC from all the other legal aids. Three children are there, one is nominated, the other two children have to give their NOC. Then this one who has been nominated gets access to the locker. Now, nomination in a cooperative housing society, that also we covered. It is only for carrying on the day-to-day transactions like paying the bills, maintenance, taxes, etc. Nomination can be on a share certificate of a flat of the society, and here he has no ownership rights during the lifetime or even after the death of the flat, shop owner, whatever, any immovable asset. Now, in the above, if the nominee is owner's spouse or blood relation, whoever it is, blood relation also, the law doesn't recognize you as the lawful heir unless the court endorses your credentials. Nomination also, we say it is mandatory and it doesn't cost you anything. You don't unlike like power of attorney you have to get it drafted, you have to get it registered. In this case of nomination, it doesn't cost you anything. So and there is a changing option also, you can go on changing the nominees. So to that extent, nomination, I think it shouldn't cost you anything, so all of you should go for it. What is the last point, Sharon ma'am? Okay,
Yeah,
can you
that's
read?
it.
That's
Nomination
it.
not compulsory, but can avoid hassles in some cases.
Yes.
Yeah. So suppose if even in nomination, okay, suppose if you are a single person and
Hmm.
you have a third person, totally not from your blood relationship, you
Hmm.
want,
Hmm. Hmm.
you
Hmm.
can put that person as nominee, but what we suggest is also make a will in the favor of that person's name.
Hmm.
Okay, so that becomes a little more because when you make a nomination, you may never know. They may say, "अरे
Hmm.
कैसे किया ये nomination? हम लोग को नहीं मालूम है." But we
Hmm.
also support it with a will. So if it's a third person outside the family, you're giving the nomination to, we
Hmm.
support that you make a will in favor of that person. Okay, and also what happens in the will normally when we also write why why we are giving totally a stranger who's not in the family, why we are giving. We sometimes we specify the reason as to why we are giving. Okay, to support, so that in the court of law it stands. There will be objections, there will be obstacles, but at least it will stand when you give clear explanation as to why you're giving a third party who doesn't belong to your family. Okay, next, any slide is there?
Here I would like to, I think this is the last one.
Yeah,
I
okay.
would like to add one thing. In a cooperative housing society, irrespective of nomination, the society
Hmm.
cannot transfer any ownership rights. So tomorrow, whatever happens, society also will say that we don't know who we are. Yes, you are a nominee. Your name is there on the share certificate, but the share certificate itself is not a, so to say, valid document to prove your ownership. So nobody should be having that notion that the society will come to my rescue, something like that.
Yeah, and the
So
share certificate is more for a schedule of the property.
yes,
So we
it
look
is
at
only
that.
for the schedule. That's all. That you are
Yeah.
residing there. That's it.
Hmm.
Nothing more than that. So I
Yeah.
think we have
Yeah,
completed on
this is
time. Yes.
it. Power of attorney and nomination. These are the basics of power of attorney and nomination, which we need to know.
Hmm.
Okay,
Hmm.
we
Hmm.
have clarity on these two topics.
Hmm. Hmm.
Yeah.
So I think
So yeah, that so
thank
now
you all of you. Now let's come to the question answers. Any questions?
Yeah, okay. Thank you, everyone. Please, we will now break and go into